Then it is my great honor and pleasure to open the 5th AIPPI Young Members Summit, our 2026 summit. We have a lot of interesting sessions, speakers, and exciting content for you prepared. But before we dive into that, let me very, very briefly just give the stage to Regina Queck, our Secretary General of AIPPI, for some opening remarks.
Thank you. Thank you very much, Nicholas. Hello, everybody. On behalf of AIPPI, I'm very happy to welcome you to this year's summit. We are extremely proud of our young AIPPI committee and of all our young members who have come together, supported each other, and grown a community together. This summit is now a signature event in the AIPPI calendar for young members. The first summit was in 2022. And as Nicholas said, we are now at the 5th summit. The community of young members in AIPPI has grown a great deal over the years. It is now an established and active group within the AIPPI family and with its own event and space at the AIPPI World Congress. So thank you very much to Nicholas and your very hardworking committee members, and also to all the speakers for making this year's summit happen. I know that you will all learn a great deal and have a lot of fun together these next couple of days. I encourage you all to participate fully with your questions and comments. It now remains for me to declare this summit open. Have a wonderful time, and I look forward to seeing all of you in Hamburg in October. Thank you.
Thank you so much, Reggie. We're extremely grateful for all of the help and support from the Bureau and SGT in particular over the years. And I can speak for the whole committee in that saying that without all of that support, we certainly wouldn't be where we are right now, with a lot of interesting, exciting opportunities and events. So before handing over to Jessica, our moderator for the session, and giving room to all of the speakers, maybe let's also give everyone here who isn't as familiar with our work as the committee a brief insight and introduction into what we as the AIPPI's Young Member Committee are actually doing. So my name is Nicholas Alexander Geig. I'm the chair of the Young AIPPI Members Committee. And you may already be familiar with the event that we are currently holding, the summit, which is our main virtual event. We're holding it every year. And this year's summit has a total of 5 sessions. So you're already attending the first one. I'm sure you're also available, hopefully, then for the other 4, which will bring additional insights. So we'll have an ideas exchange session this afternoon, European time, which will be very interesting as it will touch upon the use cases of AI that we as younger practitioners of IP law in particular are currently facing. So this is something that we will probably grow old with working with. We have a very exciting Asia-Pacific satellite session, European, Middle East, and Africa session, and America satellite session tomorrow. And you can review all of the details, the topics that will be discussed, the subject matters of the various presentations also in the summit program, which is available online. As mentioned, our committee, and you can see the current committee members here, actually has a variety of projects. So as you can see, the committee grew quite a bit. It's quite a lot of people, but it also fits the tasks that we are actually dealing with, because our aim is to make AIPPI accessible for all of its young members, to provide insights and also speaking opportunities to them. Speaking opportunities, for example, such as this summit. And these are some of the answers that were actually given by the young member community recently. I think it was one from a survey that we did last year during one of our events on what they expect us to provide. And at the same time, these are the tasks that we have set ourselves to work on. So organizing of events, providing a network for young members, facilitating, also working, for example, on AIPPI projects on a national member group stage as well. So if you are organized nationally as AIPPI young members and you're looking for ideas on how to develop projects and so forth, you can always reach out to us and we're happy to help in that regard as well. So in terms of upcoming young member events, today we're starting the summit, which will also take place tomorrow as discussed. Our main in-person event will be held during the World Congress, which Regina Craig has already announced will be held in Hamburg this year, early October. And the big young member event there will be the forum. For that, you are all invited. And if you're able to attend Hamburg, please make sure to also attend our forum to connect and experience our big in-person get-together and learning experience there. Then there's also national young member events. Many of you will know better of those or more of those than me because you're hopefully also organized nationally if there's a significant amount of young members in your national or regional group. For example, there will be, and I'm sure you will hear of that again throughout the presentations, a young member event also trilaterally between the German, French, and Italian group in Milan later this year, 20th of November. And then, of course, we're also thinking ahead about the events in 2027, for example, maybe during the midterm meeting, then, of course, summit, forum, and so forth. And you can be certain then whenever you're attending one of the big international AIPPI events, there will be someone from the AIPPI Young Member Committee around whom you can approach. And hopefully there will also be a dedicated event or meeting opportunity that you can attend that focuses particularly on you as AIPPI's young members. Having said that, let's maybe take a moment to appreciate whom we already have here in this call, every one of us as young members, and see if we can take a screenshot together to commemorate the starting of this big summit. See if I can get everyone on one screen. So if you're able to, please feel free to turn your camera on. And then to be part of this shared experience. Okay, anyone else? Otherwise, we'll give it a try in 10 seconds. Time to shine and show your teeth. Okay. 3, 2, and 1. Cheese. Okay. I'll try another one just to be sure. Okay. 3, 2, 1. Okay. Thank you so much. Having said that and having done all of the organizational part, I'm happy to hand over to Jessica, who is our moderator for this session, to introduce the speakers and some housekeeping rules, and then give you an opportunity to experience the session.
Thank you, Nicholas. Good morning, everyone. I'm Jessica Pinheiro Yarzabal, and I am the member of the Young Member Committee of APPI. Today, I'm going to be your moderator of this global session that starts the week of the 2026 Young APPI Member Summit. Thank you so much for the opportunity to be here, and I welcome you all. The global session has as topic the international trade and intellectual property, online protection, access, and global supply chains. Before we start, I have a brief introduction about the panel that says the world offers a great opportunities for companies, inventors, investors, and entrepreneurs to expand their business, especially considering the advance of digital technologies. However, one fact is certain. These players have to deal with cross-border challenges, especially for territorial IP rights. No one can escape of it if you are looking forward to international trade. But the point is, what kind of possible legal strategies and tools can be used considering the complexity procedure involved in each jurisdiction and the international rules? There is no doubt that real cases can teach us possible solutions and establish the limits or not of the IP system in question. Based on that, this global session will listen to 4 brilliant young speakers and see their perspective on how to deal with IP challenges in international trade. So I welcome you, Silvia Muñoz, Owen Waugh, Xin Xu, and Stella Frisby, that will share their ideas about this topic. So before I will read the speaker's resume to introduce you, their background. Silvia Muñoz is a senior associate in the intellectual property practice at Gomez, Sebo, and Pombo. She regularly advises national and international clients on a broad range of intellectual property matters, with a particular focus in patents, trade secrets, plant breeds rights, and IP litigation, often with cross-border implications. Owen Waugh is a solicitor and managing associate in AIPPI in the UK, dealing with patent litigation with a particular expertise in standard essential patents. Recent work includes representative parties in this year in the Supreme Court of UK in both Tesla and Intradigital and Avanci and Options versus AIPPO. Xin Xu, she's from China, is mainly responsible for assisting European companies to handle trademarks registration, assignments, licensing, reviewing, validation, oppositions, and administrative litigation. And she has accumulated 3-year experience in trademark protection and enforcement. She will deliver a speech on challenges and strategy of trademark protection for foreign and brands entering Chinese market. Stella Frisby is from South Africa. Let me read here. Stella is a candidate patent attorney. She is a Bachelor of Law. She has a lot of certificates, and she has a pretty much work experience in IP litigation and practice. So before we start listening to the experience and the ideas of our young speakers, I will share some housekeeping information. I think you can. Okay. So the global session starts the 2 days of the IP Summit. And it's important to know that this webinar will be recorded and published in the APPI YouTube channel. Questions to the speakers can be submitted in the Q&A box that you can see on your screen with the chat image. And the questions and answers should be done in the end of the session. So after all the speakers speak. And in the end, please put your opinion in our survey. And also, we remember that this webinar, they will have 1 hour and a half minutes. And, okay, it's not showing anymore. And each speaker will have 20 minutes to expose their ideas about their presentation. So let's start with our first speaker, Silvia Muñoz. Please, the floor is yours. Welcome you all.
Thank you very much, Jessica. I'll share the presentation now. See if it works. Let's see. Can you see the present? Yeah, no. Okay. Can you see it now? Yes? Okay. Okay, good morning, everyone, or good afternoon if you're joining from the other side. Thank you very much for being here, and thank you, of course, to the AIPPI and to the Young Members Committee for organizing this year's summit. Over the next 20 minutes, I would like to explore how patents, plant variety rights, and trade secrets each respond to a common challenge, which is the growing disconnect between territorial IP protection and global trade. As goods, technology, and know-how increasingly move across borders, IP enforcement is being forced to adapt in ways that would have been difficult to predict only a few years ago. Let me start with a simple observation. We live in a world where manufacturing, exploitation, and enforcement of IP rights increasingly takes place in different countries. For example, a product may be developed in one jurisdiction, then manufactured in another, and sold in a third one. The legal challenges that arise from this reality can vary significantly depending on which IP right is involved. Today, I would like to focus on 3 recurring challenges that arise when IP rights operate across borders. The first one is exhaustion. And the question is, can rights be enforced once protected products cross borders? The second is border measures, which asks, can customs authorities effectively detect and stop infringements at the frontier? And thirdly, territoriality itself. Can enforcement extend beyond the territory for which the right was granted? These are 3 questions that will serve as our roadmap. And throughout, I will ask you to keep in mind a core underlying question, which is how different IP regimes reconcile territorial protection with global trade. Let us now begin with exhaustion. This is one of the most fundamental mechanisms through which territorial IP rights accommodate cross-border trade. The basic idea is rather straightforward. Once a protected product has been placed on the market by the right holder or with its consent, the right holder can no longer oppose its subsequent distribution within that same market. In the European Union or the European Economic Area context, this serves also a broader policy objective, which is to facilitate free movement of goods despite the territorial nature of IP rights. So in practice, if a product is placed anywhere in the European Union or the European Economic Area by the right holder or with its consent, IP rights are generally exhausted throughout the entire area. However, and this is crucial, right holders may still prevent parallel inputs from outside the European Union. Now, here's where it gets interesting. As I've said, exhaustion is an essential tool for cross-border trade, but its rules are not identical across all IP categories. For example, patents and plant variety rights follow slightly different approaches. And then trade secrets, well, they are not territorial in nature and therefore have no concept of exhaustion at all. So let's see this in a bit more detail. This slide presents a comparison between the regimes of patents and PVRs, which I think is very telling. So for patents, the general rule is simple. Rights are exhausted after the first authorized commercialization within the European Union or European Economic Area. There are limited exceptions, of course, where there are legitimate grounds to oppose further commercialization, although these in practice are difficult to justify. But in the end, the key point is the place of first sale. However, for plant variety rights, the picture is a bit more nuanced. The general rule is the same, exhaustion after first authorized commercialization within the European Union, but there are 2 important exceptions where the right is not exhausted. First of all, where subsequent acts involve further propagation of the variety, and second, where the material is exported to a third country that does not protect varieties of that species. The key point in the end is that, unlike patents, plant variety rights exhaustion is not just about where the product was first sold, but also about the destination and future use of the plant material. Moving on to the second issue that we are covering, border measures. The question is, why are border measures important? Well, border measures allow customs authorities to detain goods suspected of infringing IP rights before they enter the market. That is, they are sort of a frontline defense. And these are particularly effective where infringement can be identified through a visual inspection of the good. Think, for example, about counterfeit goods which bear a well-known trademark. You can spot those relatively easily. But their effectiveness decreases dramatically where infringement depends on technical or biological characteristics of the product. In the European Union, the customs regulation provides the framework for border measures against goods suspected of infringing a wide range of IP rights, including both patents and plant variety rights. However, trade secrets are notably not included. The mechanism works as follows. Goods can be either detained or their release may be suspended upon application from the rights holder or even ex officio by customs authorities. If the right holder confirms infringement and agrees to destruction, and also the holder of the goods agrees, then the goods can be destroyed. However, if the destruction is contested, the right holder must then initiate infringement proceedings. Otherwise, the goods will be released. The cross-border challenge is obvious. Can customs authorities identify an infringement without conducting a full technical or scientific assessment in the cases of these IP rights? Well, looking at the numbers, the answer seems to be no. According to the most recent European Union report on enforcement of IP rights at the border, which covers 2024 figures, trademarks account for over 87% of all customs detentions. Patents, just 1.28%, and PVRs, a mere 0.32%. The pattern is rather clear. The more technical the IP right, the harder it is to enforce through border measures. Trademarks dominate because, as I've said, visual detection is relatively straightforward. Patents and PVRs lag far behind because assessing infringement requires expertise that customs officers simply do not have. So, what are the practical challenges? As we've said, patent infringement often depends on technical features not visible from the goods themselves. You cannot tell by looking at a product whether or not it falls within the scope of a patent claim. And the same goes for PVRs. Variety identity and the origin of the material are just not ascertainable through visual inspection alone. For trade secrets, there are simply no border measures available at all, despite the fact that the Trade Secrets Directive itself recognizes the concept of infringing goods, which are goods that in some manner significantly benefit from trade secret violation. However, looking ahead, there are some promising developments. For PVRs, rapid molecular identification tools may facilitate custom controls in the future. However, identifying the variety does not necessarily resolve questions relating to authorization of propagation history, origin of the material, or other complex questions relating to infringement, for example, essentially derived varieties. For trade secrets, the challenge is even more fundamental. Again, trade secret misappropriation is rarely apparent from the goods themselves, but also effective customs intervention would require disclosing the trade secret to customs authorities, which potentially undermines the very secrecy on which protection is based. This raises, in my view, a genuinely open question. Is customs enforcement really compatible conceptually with the nature of trade secrets? This whole debate, brings us to the third and perhaps most dynamic issue that I want to cover in this presentation, which is, can IP enforcement extend beyond the territory for which the right was granted? Here, recent developments are reshaping the landscape in ways that were barely imaginable a few years back. For patents and PVRs, both of which are territorial rights, infringement has traditionally been assessed separately in each territory where protection exists. However, recent developments and also specific tools are challenging this. In the patent world, cross-border injunctions are becoming increasingly available, as we will see in a moment. And in the PPR world, the cross-border protection of harvested material provides a unique enforcement tool that can effectively reach conducts in other jurisdictions. For trade secrets, the picture is a bit different. There is no territorial title, but enforcement is still territorial. Cross-border disputes raise distinct challenges relating to applicable law, coordination across jurisdictions, and tension between evidence and preservation of confidentiality. Let us start with the patent side, because this is where the most dramatic changes are taking place. As I've said, traditionally, patents have been enforced country by country. You had separate infringement proceedings in each jurisdiction, which were costly, time-consuming, and sometimes inconsistent in their outcomes. Cross-border litigation existed in the EU, but remained relatively uncommon. However, in the last couple of years, several developments have radically transformed this picture. First of all, the European Union Court of Justice ruling in the SHP electorals in early 2025 established that national courts may adjudicate infringement relating to foreign patent designations, even where validity challenges have been raised, thus removing a significant barrier to cross-border patent litigation. Indeed, following that ruling in September 2025, the Munich Regional Court ordered Germany's first national pan-European cross-border patent injunction, prohibiting sales across 22 European countries. That is indeed a remarkable development. Then, of course, there is the Unified Patent Court, which can issue cross-border injunctions with effects across multiple European Union member states. Also, its long-known jurisdiction increasingly allows claims concerning non-UPC patent designations. It is quite simply a game changer for European patent enforcement. In summary, patent remains territorial, but patent litigation increasingly does not. Moving on to PPRs. One of the most fascinating and currently most debated areas of cross-border IP enforcement is the harvested material exception that applies in these cases. Both the European Union and international PPR law extend protection to harvested material where two cumulative conditions are met. First of all, the harvested material must have been obtained through the unauthorized use of propagating material. Second, the breeder must have had no reasonable opportunity to exercise its right over the propagating material. These conditions are cumulative, but they open a few interpretative questions. Which breeder's right matter for the analysis? Those in the country of origin or of destination? What exactly constitutes unauthorized use? And what is a reasonable opportunity? A mere legal possibility or maybe practical feasibility? These questions are not just theoretical. They are currently the subject of intense debate within UPOV. And recent discussions have increasingly supported assessing both concepts by reference to the breeder's rights in the country of enforcement, rather than the situation in the country where propagation occurred. The cross-border implications can therefore be significant. Depending on how these conditions are interpreted and applied, harvested material protection may actually capture situations involving cultivation and harvesting activities carried out entirely outside the territory where the breeder's rights exist. Let me now close my presentation with a reference to trade secrets, which present a fundamentally different set of challenges. Unlike patents and PVRs, trade secrets, as we've said, are not territorial rights in the traditional sense. There is no registration, there is no grant limited to a specific territory. Protection arises from the fact of secrecy itself. This has important consequences for cross-border enforcement. When acquisition, use, and disclosure of a trade secret occur in different countries, determining the applicable law becomes genuinely difficult. Also, coordinating enforcement across multiple jurisdictions each with different procedural tools and different remedies, adds another layer of complexity. And then there is also the fundamental paradox of trade secret litigation. To prove misappropriation, you often need to reveal the very information you are trying to protect. This paradox is especially acute when evidence needs to be gathered across borders, in jurisdictions with different disclosure rules and different approaches to confidentiality in litigation. In Europe, the Trade Secrets Directive provides tools to preserve confidentiality during litigation, but it is in the end a directive, so enforcement mechanisms and procedural safeguards still vary significantly between jurisdictions. In the end, trade secrets do transcend borders, but evidence and enforcement do not. And with this, I want to just close the presentation with 3 very simple observations. First of all, exhaustion remains one of the key mechanisms through which IP rights accommodate cross-border trade, although different rights do so in different ways, as we've seen. Second of all, the effectiveness of border measures decreases significantly as infringement becomes more dependent on technical, biological, or confidential information issues. And finally, while IP rights remain fundamentally territorial, with the exception of trade secrets, of course, the challenges of enforcement increasingly do not. The examples we have seen today, from the EPC to harvested material protection for PVRs to trade secrets disputes, show that the future of IP enforcement will increasingly be shaped by questions that do not stop at national borders. And with that, I would like to thank you all very much for your attention, and I look forward to your questions at the end of the session.
Thank you so much, Silvia, for your great exposition. Now, moving forward with our panel, I'm gonna please, Owen, share your ideas about your presentation that will talk about EU's WTO standard essential patents complaints versus China, standard essential patents, TRIPS, WTO, and global trade. Please, Owen, the floor is yours.
Great. Just first a disclaimer that the views expressed in the presentation are my own and not the views of my employer or any client. So there's a few definitions to get things started off, because it's an area of the law that loves an acronym. SEPs are standard essential patents, which are essential to standardized technology. A common example is a patent which is impossible to avoid using if you're going to make a 4G phone. SSOs are standard setting organizations, sometimes also called SDOs for standard developing, and they often have IPR policies, which are intellectual property right policies that govern the use of standard essential patents. WTO is the World Trade Organization, and TRIPS is a legal agreement between the WTO members on trade-related aspects of intellectual property rights. So with those definitions, we'll get cracking. Right. So the concern that's been raised by the EU's recent complaints is the compatibility of national legal proceedings, global SEP licensings, and the WTO member nations' obligations under the TRIPS agreement. But against these concerns, it's important to remember the WTO and standard setting organizations have important fundamental goal, which is to promote global trade and global standards. This can be seen from their aims, which I've taken from their respective websites of the WTO and one standard setting organization, the International Telecommunication Union. But there are similar statements on other websites. And the benefits of global standards set by SSOs are numerous and obvious. To take a clear example from the cellular industry, for those of us old enough to remember 1G and 2G phones, you had issues where you couldn't buy a phone in one country and guarantee it would work in a different country. For example, American phones didn't work in Japan, and European phones didn't work in America as well. But nowadays, if you buy a 4G phone, it can be manufactured in one country, purchased in a second country, and it will work in basically every country in the world, which is, a huge boon to global trade and to everyone's benefit. So the TRIPS, this is the preamble to the TRIPS Treaty, which again aims to encourage international trade by promoting effective and adequate protection of intellectual property rights, but also to ensure that those measures, procedures to enforce intellectual property rights do not become barriers to legitimate trade. And this obviously makes sense. You're not going to go trading in a country if you know that your rights will be ripped off. You know that you'll produce a good and immediately somebody can produce one with the same trademark, or your patent can be exploited without your consent. But we also know that if rights are too easily enforced, if there's no chance to challenge the validity of patents effectively or so on, it means that legitimate trade in products might be hindered. So it's about striking that balance. So getting now to the relevant article of the TRIPS Treaty, which was the heart of the EU's complaint. There's also an important article which predates this, Article 1.1, which is about requires members to give effect to the treaty. And then Article 28 is the heart of the complaint as it relates to patents. And Article 28.1a says that patent owners shall have the exclusive right to stop others, using that product. This is the product one. There is an equivalent process one, but I haven't quoted it. And Article 28.2 also guarantees that patent owners shall have the right to assign, transfer, succession patent, and to conclude licensing agreement contracts. That's very important in the field of SEPs, where the aim is to license parties to your standard essential patents. Unsurprisingly, for a talk given to IP lawyers, I suspect we find most of this pretty unobjectionable. And given that patents are harmonized around the globe, I think most countries would already comply with these requirements. And so with that background, this brings us to the EU's first complaint against China in this area, DS 611, enforcement of intellectual property rights. The background to this is that between August 2020 and December 2020, the Chinese courts, where the Chinese courts were determining brand issues, issued a series of injunctions, often termed in the translations I've seen as behavior preservation orders, which prevent patent owners from seeking injunctions in Europe. These injunctions were granted by the Chinese courts based on Chinese civil procedure law, and they also included circumstances where the Chinese courts were determining a China rate only, and the patent owners were prevented from even seeking an injunction on their German SEP. So I think that was the most extreme case scenario. Following this series of injunctions in 2020, in 2021, the EU sent an official request under the TRIPS agreement for information from the Chinese government related to these decisions. The Chinese government said it was under no obligation to provide requested information and sent back a very short response with very little information. Following this, then in 2022, the EU issued this complaint relating to the ASIs, and a variety of countries provided their views on it, including Australia, Brazil, Canada, Japan, South Korea, and the USA. And actually, it's been noted that the practice of the Chinese courts granting these sort of anti-suit injunctions dropped quite a lot after the EU started making these inquiries, and certain EU courts started granting anticipatory anti-suit injunctions against the relevant parties. For those who had the pleasure of working these types of cases, there have been a proliferation between courts of anti-anti and anti-anti-anti, and a proliferation. I think the most I've seen is a 5 anti-suit injunction. So yes. And the heart of the EU's complaints is that the ASI policy of China violated TRIPS because it prohibited the patent owners in foreign countries from enforcing their rights, which was contrary to Article 1.1, which required China to give effect to that. So the arbiter, award of the arbiter, his primary conclusion was that the EU was right on the correct interpretation of the TRIPS agreement, that Article 28.1 must be read in conjunction with Article 1, and therefore members must not frustrate a patent owner's ability to exercise its rights in other member states. It upheld the finding that the China's ASI policy existed, and found that China's ASI policy was inconsistent with Article 28.1 because it did interfere with the SEP owners' rights to enforce their patents in Europe. This perhaps a surprising result, given that the ASI policy in force at the time meant that even if China was determining a rate only for China, it would prevent people seeking injunctions on German SEPs, say. They then also went on to consider the second argument, which related to the right to conclude licensing contracts. The logic here again, they upheld the EU's view that it had to be read in conjunction with Article 28.1.1. And they found that the ASI policy did indeed prevent the right to conclude licensing contracts because it interfered with the SEP owners' rights. The logic here requires a few more steps. The basic freedom provided in 28.2 is that patent owners should be free to conclude licensing contracts. And that's obviously a great benefit to global trade if, the big phone makers, for example, can, legally make their phones across the world and they have the right owners' permission to do so. SEP owners have limited their rights to negotiate a contract by agreeing with contracts with the SSO, where they agree to license on the particular contractual terms those standard-setting organizations set out. When trying to license on FRAND terms, the SEP owners obviously want to conclude licensing agreements with implementers as they want to get paid for their technology. But the economic incentive for implementers is frankly not to pay for a license at all. But the incentive to keep them honest, as such as it were, is that they must negotiate in good faith for a FRAND license acquired by the SSO, as if you don't negotiate in good faith, there's a threat that you will be injuncted, and that keeps the balance in play. Removing the threat of an injunction by the ASI policy thereby undermines the basis on which SEP owners have agreed to contribute to the standards and their rights to conclude a license, and was therefore inconsistent with Article 28.2. The WTO arbitrator therefore upheld the EU's complaint against China. The arbitrator also upheld the initial finding that China had breached its transparency obligations under the TRIP agreement as well, because it hadn't been transparent about the judgments and the ASI policy. Following the decision of the arbitrators, China's agreed to implement the findings, and so this particular dispute relating to the ASI policy has been resolved. This brings us to the EU's new complaint. In November 2023, Chinese first instance court determined the worldwide terms for a FRAND license for cellular technology without the patent owner's consent. The EU wrote to the China about this decision, and having not reached a resolution between them following several rounds of correspondence and again arguments about transparency, the EU's brought a new complaint. It takes issue with it. And again, it relies upon Articles 28.1 and 28.2. Again, a variety of nations, including Canada, Japan, and the UK, have requested to give their input. The UK's request to provide input is notable, given that a judge at the Unified Patent Court of the European Union recently reported the UK courts to the European Commission and alluded, whilst making that report, to the EU's complaint against China. So given, and the result is obviously to be determined, so I don't think there's a first instance one, and it's not the speediest process, the WTO dispute resolution process. So the way forward, as I see it, the WTO's award in DS 611 stated explicitly that the TRIPS agreement does not address issues of private international law. SSOPI policies create privately enforceable contract governed by the relevant law. And here, for example, is the ITUT, the International Telecommunication Union's patent statement licensing declaration, which patent owners sign up to when they develop the standard. And it says they're prepared to grant a license to an unrestricted number of applicants on a worldwide non-discriminatory basis and on reasonable terms and conditions. So I think the way to resolve this issue is that WTO member states should remember, therefore, permit patent owners to bring patent infringement globally where licenses have not been agreed. As the arbitrators and courts have recognized around the world, the only incentive for implementers to take FRAND licenses is the threat of injunctions and legal proceedings. If there's no threat of injunctions, many implementers will simply not take licenses. This hinders global trade in multiple aspects, as patentees will not get paid. The incentives, and therefore the incentives to innovate will be hindered, and those implementers that actually do the right thing and take a license will be hindered in their competition globally against those that don't pay. But of course, implementers should be free in those proceedings to bring FRAND defenses so that patent owners cannot get unfair, unreasonable, or anti-competitive rewards for their innovations. And then implementers should be restricted to enforcing the relevant private contracts with the SSOs and not using domestic law to determine global FRAND licenses. Patent owners have signed contracts, and implementers should be free to avail of themselves of the contractual rights they're entitled to under those contracts. But that is a private contract which is limited by the governing law, the relevant terms and conditions, and the court should not go further. I think the recent judgment of the UPC and Interdigital v. Disney is very instructive on this. The UPC found that the video encoding processes, so this was about, so it's a dispute about video encoding, and the video encoding processes for streaming are not part of the specifications which are standardized. Only the decoding processes were standardized, and therefore the encoding processes were not within the scope of the patent owner's FRAND declaration to the ITUT. The ITUT has made a conscious choice not to include video encoding with its IPR policy, and that's what patent owners have agreed to. If a court or government were to impose a FRAND determination on video encoding processes, it would circumvent the agreed contractual balance. And that's the sort of thing, you've just got to enforce the contract. Your rights are limited to what that contract does or does not say. And such an analysis is essentially also going to be fatal to getting anti-suit injunctions, whether in the UK or elsewhere or China or in the EU, to prevent litigation in foreign courts. As standard-setting organization, IPR policies do not in general mandate any particular dispute resolution mechanism. It is a known feature of them, but it is a feature, not a bug. People were aware that they didn't contain dispute resolutions when they drafted them. And if companies or governments think there are issues with SSO IPR policies, they can be amended, whether to change their scope or to introduce dispute resolution mechanisms. The US government lobbied the EU and the ETSI to amend ETSI's IPR policies in the 1990s, and those lobbying efforts succeeded. And the IEEE has amended its IPR policy twice in recent years following lobbying by various companies. So it can be done. And if people want to change what the contracts are, they should amend the contracts that way, rather than doing it through domestic case law or legislation. But this is obviously a developing area with ongoing disputes between the courts around the world. So we'll see what this WTO says about the EU second complaint. And with that, that is the end of my presentation. Take any questions at the end.
Thank you, Owen. Thank you so much for your exposition. Now, moving to our third speaker, Xin Xu, will talk about IP practice under the trade rules for foreign enterprises entering Chinese mainland. Please, Xin, the floor is yours.
Thank you, Jessica. Hello, everyone. It is a great honor to deliver a speech in this Young Member Summit. And I have been working in the trademark field for 3 years, focusing on helping European businesses protect and enforce their trademark rights in China. Before starting my speech, I would like to share with you a typical case. That's one of our clients, a famous footwear brand from Germany. As the client's reputation spread worldwide, the Chinese market soon became a key growth target. But the brand encountered unexpected problems. Numerous counterfeits, being recognized as a generic name, similar registrations and use, misidentification among consumers, and etc. The client was overwhelmed. There were too many infringers and diversified kinds of infringement. However, their budget was limited. And worse, they were losing confidence in the Chinese market. That's when we stepped in. We conducted a full-scale analysis of the infringement landscape. Instead of trying to take down every small seller, we identified the largest and most visible infringers and launched targeted legal actions. We also submitted substantial evidence to prove the client's high reputation after long-term use and promotion, as well as the obvious bad faith of the adverse party. On top of multiple administrative actions, we also filed a civil litigation based on trademark infringement and unfair competition. Eventually, we received a favorable judgment. The court not only ruled in favor of the client, but also recognized their trademark as a well-known trademark relating to goods footwear, and also awarded a desirable amount of damages. This case was a turning point. It showed our client that Chinese legal system can and does protect foreign brands if the right strategy is used. What I want to share with you today are some of those lessons I learned from real cases during the past 3 years. So let's dig into the challenges we are likely to face when foreign brands entering China, and more importantly, what we can do about them. Challenge 1, trademark squatting. Squatting happens when dealers, competitors, or professional squatters register a foreign brand trademark before the brand enters the Chinese market. There's the iPad case. When Apple launched the iPad, they discovered a Chinese company had registered iPad years earlier. $60 million later, Apple owned the trademark. $60 million for what should have been routine registration. Reclaiming a squatting mark bad faith filing isn't impossible, but it's complex. China does have mechanisms for invalidating bad faith registrations, but these procedures take years and require substantial evidence. Challenge 2, Chinese character marks. When foreign brand enters China, they face an unavoidable question: how will Chinese consumers know us? The answer is through Chinese character marks. However, the English brand name has no inherent meaning in Chinese. They need to choose a suitable and corresponding in Chinese characters. Take Coca-Cola as an example. When the brand first entered China in late 1920s, the early local translations were a disaster. One version, 可可肯辣, means a tadpole biting the wax, which sounds unappetizing and seems the same as the sales. In 1928, Coca-Cola ran a global contest in the Times, offering a £350 prize for a better Chinese name. And the winning translation, 可口可乐, is now widely regarded as one of the finest translation we can learn from. And nearly a century later, these 4 characters still anchor Coca-Cola's identity in Chinese market and as a core legal asset in their own right. And the brand value it has created in the Chinese market often even exceeds what it has achieved with their original English name. Challenge 3, procedural complexity. Understanding China's dual track system, the administrative track and the judicial track, is essential for all of us practicing in this place. The administrative track offers speed and relative simplicity. For straightforward counterfeiting, this works well, but administrative enforcement has limits. Administrative fines will not be directly compensated to the right holders. Evidentiary standards can be demanding, and the outcomes vary by jurisdictions. For nuanced legal analysis, whether 2 marks are substantially similar, or for example, administrative procedures may not provide thorough examination needed. The judicial track offers stronger remedies. Court proceedings provide greater procedural protections and comprehensive legal examination. China's specialized IP courts has developed real expertise, but litigation is challenging. Complex cases take 2 to 3 years through all appeals. Costs pile up. Damage awards has increased, but proving actual damages or infringer profits remain difficult. Now that we have covered all the challenges, let's move on to the strategies. These approaches can help protect the foreign brands effectively. First, early registration is the foundation. In China, first-to-file system means whoever files first usually owns the right. This creates a high risk of infringement if not addressed early. What should you register? At minimum, file your brand name in both English and Chinese versions, covering all relevant goods and service classes. For most goods you would like to sell in China, Class 35 relating to advertising and business management and product-related classes are essential. Second, brand localization is the key to long-term success. Brands may attach great importance on the trademark translation and their products combining local preference. Denmark's Lego localizes products like Chinese New Year sets. Pop-Mart's Labub wears Thai princess dresses in Bangkok. Localization will not only boost sales, but also strengthen the brand loyalty among Chinese consumers. Strategy 3, proper use of international rules is essential for leveraging the complex legal systems. When European clients register trademarks in China, they enjoy the priority right according to the Paris Convention. If they have basic application in their own country, they can apply for the same trademark in China within 6 months and enjoy the priority date of first application. This can effectively prevent others from preemptively registering identical or similar marks in China. Finally, continuous monitoring and choosing the right enforcement path are crucial. Once marks are registered or even while applications are pending, ongoing monitoring is critical. When the potential conflicts appear, act quickly. Opposition must be filed within 3 months of publication. If the mark has already registered, invalidation is available throughout its life, though after 5 years, the bad faith must be affirmatively proven. Non-use cancellation becomes available 3 years after registration, but its success rests almost entirely on the use evidence submitted by the adverse party. For established infringement, 3 tracks can be taken into consideration. Administrative complaints are the fastest and simplest route and highly effective for clear-cut counterfeiting. Judicial litigation is slower and more expensive, but delivers the broader remedies clients actually need. Platform complaints offers the quickest response to online infringement. Major Chinese enforcement e-commerce platforms have mature trademark takedown procedures that resolve within days. The right method or combination of methods depends on infringement's nature, the available evidence, the client's budget, and the outcome they want. That's all for the above-mentioned approaches to cope with diversified infringement in the Chinese market. Looking ahead, I'm optimistic about Chinese IP protection developments. The government has substantially invested in strengthening enforcement, establishing specialized IP courts, and increasing the infringement penalties. Foreign brand owners have great access to effective remedies than ever. As a trademark practitioner with 3-year experience in supporting European companies in China, I have witnessed how strategic IP management transforms market entry from risk to reward. The brands succeeding in China treat trademark protection as core business priority. They invest in proactive registration, continuous monitoring, and sophisticated enforcement. They build evidence portfolio, enabling effective actions. For the fellow young practitioners, I want to end up with something personal. When I started 3 years ago, I felt overwhelmed by the Chinese trademark complexity. Sometimes I still do, but every case teaches something new. Every challenge builds capability. Every client success reinforces why trademark protection matters. We are all learning together, and we are all figuring out how to best serve our clients in this challenging but rewarding space. I feel grateful for the chance to share what I've learned so far, and I look forward to learning more alongside all of you. That's all for my sharing. Thanks for your listening.
Thank you so much. Thank you so much, Xin, for exposition, and also to sharing your personal challenges facing in your daily practice. Well, moving with our fourth speaker, who is Stella Frisby. She will cover the topic international trade and IP in Africa, talking about the regional protection and the enforcement and market access. Please, Stella, the floor is yours.
Hi, everyone. My name is Stella Frisby. I am a candidate patent attorney at Han & Han Inc. in South Africa, where I've been working for the last 6 years, doing patent drafting and prosecution throughout Africa. I have a BSc in Agriculture and Food Science and Technology, as well as an LLB. Sorry, I'm just making sure is my screen still being shared, Jessica?
Yeah, it's visible.
Oh, thanks. Okay,
Yes.
perfect. So my topic today is international trade and IP in Africa. So when one thinks about international filing strategies, immediately most people's minds go to filing in Europe and the US, China. But you should not forget about filing in Africa. Africa is often not considered or only considered much later, which is not good because Africa is home to 1.4 billion people, has a combined GDP of approximately 3.4 trillion US dollars, and is rapidly growing in their consumer markets. It also has some of the fastest growing economies in the world, and there's been rapid digital transformation in sectors such as mobile connectivity, fintech, digital payments, and e-commerce. And with the expansion of 5G, we've seen a huge increase in patent filings across Africa. And with that, obviously, comes opportunities for licensing. And to show you what I mean, I've taken some screenshots of news reports and businesses reports that outline this. And as you can see, Africa is one of the world's fastest growing digital economies. Mobile connectivity has transformed banking and payments and brought with it large investments. And like I said, we are seeing a huge increase in the number of patent filings and activity surrounding these technologies. And the next part of this will obviously be licensing. So for young IP practitioners, Africa is only going to become more important, and you don't want to get left behind as this goes on. If we take a look at ARIPO, for instance, and we look at the 2024 patent filing trends, we can see that they were dominated by pharma and tech in 2024. And in 2025, pharma was overtaken by tech innovations in ITC and telecoms, and huge investments are pouring in on the IP front for these technologies. Africa can sometimes be confusing for a lot of people. When people think of filing IP in Africa, they often think of Europe, and it's just not the case in Africa. There are 54 countries in Africa, and although there is some economic integration, the IP systems are quite diverse. Some countries belong to regional organizations such as OAPI and ARIPO, whereas other countries operate entirely independently of these systems, such as in Nigeria, Egypt, Ethiopia, and South Africa. And with these differences comes differences in examination practices, as well as enforcement. And one question we get asked a lot about is enforcement. People don't believe that there's enforcement in Africa, but honestly, that's not a problem in a lot of countries. And your worry should be missing out on filing applications in Africa rather than enforcement. If we have a look at some of these systems in Africa, if we start with ARIPO is mostly Eastern and Southern African countries that are historically linked to British legal traditions, and it also includes some former Portuguese colonies such as Mozambique and São Tomé and Príncipe. And they joined together to form ARIPO because it just made economic and administrative sense. If we look at what's been happening in ARIPO in the last few years, in 2024, they launched a bilateral patent prosecution highway program with the CNIPA. And that allows applicants to request accelerated examination based on patentable claims in either office. In last year, there were some big changes to the Harare Protocol, mostly administrative changes, but also changes to deadlines and a huge increase in official fees. And our firm has a very good relationship with ARIPO. We have personal experience with the examiners who are of good quality and consistently produce good quality examination reports. And we have a partner at our firm who visits their offices in Zimbabwe regularly for feedback, which they are very responsive to. If we look at OAPI, which is the other regional organization in Africa, it's comprised of mostly East and Central African countries, or historically those linked to French legal traditions. And recently we've also had an increase in official fees there, but the most important change in OAPI is the introduction of examination for patent applications filed after the 1st of January 2025. We are yet to receive an examination report from OAPI, so we're excitingly waiting to see what happens there. I'll discuss Nigeria and South Africa in a later slide, but just to touch on AGPO in Egypt, we're currently seeing that they aren't accepting a lot of pharmaceutical patents at the moment. They're being quite strict with those. And with the Ethiopian Intellectual Property Office, for a long time, there were delays in progress with applications, but recently we've noticed that there's been an increase in their processing time, which hopefully suggests a commitment to improving their performance. Although there are two regional organizations in Africa, they are actually quite different. They both provide regional protection, but ARIPO complements national IP systems, whereas ARIPO replaces them with a single harmonized regional system. So when filing in ARIPO, you must designate member states in which you want protection, whereas OAPI, this protection is automatic across all of their states. If we have a look at Nigeria and South Africa, both of these national offices are depository systems for patents currently. If we look at Nigeria, they are Africa's largest economy if we look at nominal GDP. And South Africa, on the other hand, is one of the largest industrial economies and among the strongest IP enforcement jurisdictions in Africa. If we look at Nigeria, at NIPO, in the last year or so, we've noticed a huge increase in the processing speed of Nigerian applications. They are getting granted within 2 months of filing, and that is something that we've now been seeing quite consistently. If we look at the CIPC in South Africa, it's also a depository system. And from the administrative side, patent applications are processing remain consistent and within generally reasonable timeframes. And in South Africa, we're actually preparing for major reforms to our patent and design law. Some of the changes including search and substantive search and examination for patents, as well as the introduction of utility models. The draft legislation for this was meant to be released for public comments in February this year, but there have been a number of delays, so we're not sure when that's going to happen, but it is on the horizon. In the meantime, if you have patent applications or filed any in South Africa, you might be aware that for the last few years, we've been running an experimental learning program with support from WIPO and the EPO to train our future patent examiners. And as part of this program, they conduct voluntary non-binding search and examination for training purposes. And that seems quite promising. What else? Despite the fact that we are a depository system, patents are actually taken seriously in South Africa. We have a very well-developed legal framework and a specialized patent court as well. The Court of the Commissioner of Patents, which handles patent disputes and litigation. There is litigation in that area. If you have South African patent portfolios, you may already know there was a recent decision regarding assignment of inventions and their effect on validity of patents, which highlighted for everyone the importance of ensuring that IP ownership is clarified and documented properly from the start. So I've sort of talked about the national and regional offices in Africa, and there's obviously some disconnect. And there's also a bit of a disconnect between trading among these throughout the continent. And that obviously needs to be addressed. And something that has been introduced by the African Union is the African Continental Free Trade Agreement, or the AfCFTA. This is a flagship initiative of the African Union's Agenda for 2063, which is basically a long-term blueprint for Africa's economic and social development. And it seeks to develop a single continental market for goods and services with a view of making business and trade in Africa, but also outside of Africa, a lot easier and encourage investment. So this agreement was needed because historically there's been surprisingly low inter-African trade. Only around 15 to 18% of Africa's total trade has been with other African countries. And by comparison, inter-regional trade is significantly higher in regions such as Europe and Asia. And one of the reasons for this low level of inter-African trade is that African markets have traditionally been quite fragmented. Businesses had to deal with tariffs and other non-tariff barriers such as custom procedures and different regulatory systems. And for these reasons and other historical reasons, it's made cross-border trade quite difficult and also expensive. So the AfCFTA seeks to address these challenges by encouraging inter-African trade and industrialization, but also attracting foreign investment and improving competitiveness throughout the world. And obviously, as trade becomes easier and businesses begin to operate throughout Africa, IP becomes increasingly important. And companies need to start thinking of effective strategies to protect their brands and technologies and innovations across Africa. And to show just how important this AfCFTA is, if you can see from this image, as of June 2026, all African nations except Eritrea in the corner here have signed the agreement and most have had an instrument of ratification deposited, which makes the AfCFTA the largest trading bloc, second only to the World Trade Organization. So it is quite big. So we've discussed why the AfCFTA came into being, but if we look at the timeline of where things are going, so the agreement was adopted in 2018, was entered into force the year after, and in 2021, trading under the AfCFTA commenced. And the AU will seek to progressively eliminate about 90% of the tariff barriers within the next 10 years. That's their goal. And interestingly, in 2023, an IP protocol was adopted by the AU. And in the next 2 years after that, annexes to the IP protocol were adopted. So this IP protocol doesn't focus on the replacement of IP laws in African countries, but rather cooperation between the states. The IP protocol hasn't come into force yet. It will only come into force once 22 member states have ratified it. And at this point, there hasn't been a single state that has done that. So there's still probably a long way to go. So if we look at the protocol itself, although it's not in force, and like I said, it's not focusing on the replacement of IP laws, but rather cooperation. So their objectives are very clear. They are to support inter-African trade, deepen intellectual property culture in Africa, promote coherent IPR policies and harmonization, encourage negotiation positions for IPRs, and support creative and cultural industries, as well as public health and priorities of state parties. So that all sounds great, but what does the protocol say? How is this going to affect everyone? So if we look at how it could possibly affect trade in IP, there are articles on most favored nation treatment, national treatment, and exhaustion of IPRs. And to go back to Silvia's presentation, although there hasn't been an annex developed to this degree, we assume that it might follow the European projection, which would help discrimination between trading partners and also provide a bit more predictability for businesses who seek IP protection across Africa. If we think of how will they achieve this greater integration, Article 23 and 24 speaks about the areas of cooperation and what is expected from member states. With regard to strengthening enforcement, the protocol provides general provisions for the enforcement of IPRs, as well as responsibilities for state parties and injunctions. Again, linking back to Silvia's presentation, this is still a challenge in Europe, so it'll be interesting to see what happens here. And implementation does take time anyway, and as of now, the IP protocol is not yet in force, and time will tell what will be developed in terms of the annexes to the protocol. So one interesting article in the protocol is for the proposed establishment of an AfCFTA Intellectual Property Office, or AIPPO. And we're not sure what this is going to look like, if it'll resemble a regional office like ARIPO or OAPI, and what their functions will be. That will still need to be developed as time goes on. But we assume that they will cooperate with the national offices as well as the regional offices. So to summarize, as I've said, Africa has had a fragmented IP landscape and a trade landscape, and national and regional IP offices are strengthening their IP systems and reforming their legislation, as we saw in South Africa and ARIPO and OAPI. And the recognition of the importance of IP is growing, especially with trade, as we saw with the AfCFTA, and continental harmonization is the long-term goal. So what would this look like in the future? This is a diagram which shows the estimates from the UN Economic Commission for Africa for the impact of a fully operational AfCFTA by 2045. And economically, the impact is quite impressive. An increase of trade by 45%, a GDP increase of 1.2%, and then inter-Africanly, increase in agri-food trade by 60%, industry 48%, energy and mining 28%, and services and trade 34%. So it is very promising, that's for sure. So this is my last slide, and I'd like to leave you with the message of don't overlook Africa. My hope is the next time you're discussing international filing strategies with your clients, that Africa isn't the final jurisdiction that you think about. It's part of the conversation from the beginning. Because as someone who's prosecuting applications throughout Africa, I can tell you that your competitors are already here and you cannot afford to get left behind. Thank you very much, and hope to see you guys at the 2026 AIPPI Congress.
Thank you so much, Stella, for your great exposition. And first of all, I'd like to congratulate our 4 speakers for the interesting presentations, because you covered a complex topic that involved the local and cross-border challenges, as you can see by each presentation. We have around 8 minutes for questions. So I have my questions because I thought very interesting each exposition. They complete each other in a way that make these sessions very, very, very complete. So Nicholas, I'd like to know if we have time for 2 questions.
Of
I mean,
course.
1 question for each speakers and a general one to
Of
finish.
course, and also from the audience, hopefully.
Yes, definitely. So to warm up, because I know that our audience probably have so many doubts about these expositions, I will start with Stella. So Stella, in your practice, how do you deal with the challenges of enforcement in Africa? How do you see? Because this was a point that you brought in your.
So I think one important aspect in African practice is our relationships with the different organizations and with our partners across Africa. And I think if you're in the right hands, things can obviously be a lot easier. So it is a bit difficult to say because there are so many different organizations that can be dealt with. But I think a lot of people think, like in China, the enforcement is a problem everywhere and you can never get results. But that's just not true. I think it depends where you are. And we have a saying in our offices, TIA, this is Africa. We sometimes can't predict what's going to happen. And we often are surprised by the results. So I'm not sure if that really answers your question, but yeah, it's worth filing because I think people, would be impressed by enforcement in a lot of the countries in Africa.
Thank you so much. And I have a question for Silvia. Silvia, would you like to understand what role do you think the attorney should play to deal with the border measures when he's facing the practical challenges, considering the nature of each IP rights that in question that you covered, and here especially when it's talking about trade secrets?
Well, as I've mentioned during my presentation, it's difficult when rights are not just, like immediately evident from the good itself. It's actually difficult in practice because there are technical assessments involved, there are biological issues involved. And in the particular case of trade secrets, I think it's even more difficult in a way, because in the end, with patents, with plant variety rights, you can you can file an application, you can inform the authorities of your right, you can give some sort of indications. With trade secrets, a lot of the movement, the cross-border movement of trade secrets will not necessarily happen through physical goods. It will happen through movement of employees who carry knowledge. It will happen through movement just of information. But even where the trade secrets travels through the good itself, as I've mentioned, it's even more difficult than with patents, with PBRs, to just inform the authorities. You face an additional risk of your confidential information, your trade secret being disclosed, because there are no particular measures in place. You are not certain how the information will be treated. It's a significant risk. So I think it's more difficult for trade secrets than for other technical rights, but still a bit impractical in my experience in all sort of hard IP rights.
Thank you so much. So before I move with my question for Owen, just remember people that, to the audience, that you can't make the questions in that box that says Q&A. So don't be shy, please. Would you like to know what do you have in mind? So Owen, would you like to know, my question is, how do you develop a priority strategies for enforcement of IP rights, considering the peculiarity of the IP system in the jurisdiction that will defend your client's rights?
Well, I suppose it always depends on what the client wants in particular. And then you just have to look at the remedies that are available in different countries. I know in the field of SEP litigation, it's difficult to get injunctions in America because of eBay and Merck exchange, and injunctions are more readily available in the EU and the UPC. You have to take into account the BA section Electrolux, the possibility of enforcing non-European patents in European courts, but there are a lot of issues with that, both at the enforcement level and the possibility of retaliation by those foreign nations. There's a lot of appeal and SEP litigation in the UK currently because of the potential for royalties and interest going all the way back to first sale. So that's appealing to some patent owners where there's a long period of unlicensed use. So it really depends on the particular features of the client and what they want out of it. But you've got to take into account all those sorts of factors.
Perfect. Thank you so much. And Xin, how did you convince the client to focus on major infringers instead of all sellers?
Thanks for your questions. And I will convince the client that small cases will drain budgets but have no market impact. By prioritizing the key influencers, we showed that defeating them would set a precedent and deter other small infringers. Besides, the damage we gained from the favorable judgment can also cover the expense in this case and also be used in defending other infringers. That's all for my answer. Thank you.
Thank you so much. Nicholas, we still have time for more than one question because it's almost finished 1 hour and 30 minutes, just to be sure.
Sure, you can do another question. So I'm sure we all have another 2, 3, 4, 5 minutes. Particularly if the
Thank you
audience
so
has any
much.
questions, now would be the perfect time, I guess.
Yes, exactly. Well, my point is, how do you develop? Okay, so I could see by our presentations that besides the cross-border challenges in practice, we can see also a limit budget sometimes from our clients. So could be also another challenge to solve the client's issues. So based on that, how do you develop priority strategies when you are facing this kind of challenge when the clients have a limited budget? So please feel comfortable to share your idea.
I'll share mine if no one else wants to step in. I think, as I've said during my presentation, for example, I think it's changing a bit in Europe as a result of the UPC working, because it's just changed a bit in the sense that now you do not need to go to every court and to prioritize markets. You can directly go to the UPC and it will cover in practice the whole European market. But where there is still this difficulty, I think in the end, it's when there are budget restrictions, it's an issue of which markets are the most commercially important for the client. Where do you actually need the enforcement to take place to preserve your market share, to preserve your business? I don't know if anyone else feels different or has any additional ideas.
Maybe just to add to what Silvia is saying, or to agree with what she's saying, it depends on where you want to commercialize your products. If you have limited budget, the places you go first obviously are the places where you're planning on commercializing and selling your products, I guess.
Well, Owen or Xin, would you like to share your thoughts?
Well, I mean, there is just the issue with people who value portfolio licenses of cutting away too many countries, and you do end up with gaps in protection that related to government. So I think sometimes trying to persuade whether it's an internal, account manager or whoever to pay a bit more to maintain patents in a few more territories is often, I think, worth it in the long run. But I appreciate that, people have their own internal pressures that mean that's not possible.
Well, I think that I will first conduct the trademark and infringement analysis in terms of the trademark field, and I will conduct this action to identify the most impactful targets for crackdown, and this will give the consumers confidence in the markets, and also the more enlarge their budget to the further actions. That's all for my answer.
Thank you so much. Well, since we have already the advance of the time, I think we have to finish this first global session, this first session. And I would like to thank you so much for your time and for submitting your presentations. They were very, very interesting and very great to hear your vision about the topics that you covered. And please don't miss the next sessions that we'll have today and also tomorrow. So I'm saying this to the audience and also to our speakers. And please, I wish a happy IP Summit. So Nicholas, would you like to say a few words to close?
I think that was excellent. Thank you so much, Jessica, and everyone for your great moderation and contributions as speakers. And to all of you who are still here, please make sure to tune in 2 hours' time for our big learning sharing session on AI use cases, which will happen as our next step during the summit. Okay, see you hopefully then.
Thank you.
Bye-bye.
Thank you very
Thank
much.
you. Bye-bye.
Thank you. Bye.